Hello again. In our health and science focus on this Wednesday morning, we're talking about the use of cannabis and cannabis products. Well, let's get back to some of the legal implications around possession and use of cannabis now. Now, in 2018, the Constitutional Court ruled that it's legal for personal and medical use, but it is still unlawful to consume it outside of your home. Now, Justice and Correctional Services Minister Ronald Lamola has published the draft Cannabis for Private Purposes Bill. It outlines proposed possession rules for users and cultivators. The draft law says that a person found with more than 1 kilogram of dried cannabis or 9 flowering plants could be jailed for up to 15 years. Well, Paul Michael Keichel is an attorney with a legal firm that specialises in cannabis matters. He chats to us via Skype this morning. Paul, a very good morning and thanks so much for your time this morning. So clear up for us, because there's still some uncertainty around this as we wait for government to, sort of put its stamp on this. Over the use of cannabis and cannabis products, where are we at the moment?
Look, the bill is a step in the right direction in that Parliament, as it was required to do, has actually put together a draft in response to the Constitutional Court judgment. You do need to keep in mind, though, that it is still a draft and it does still need to be opened up to public comment and public participation. So there are going to be challenges to it. There are going to be a lot of people who have a lot to say about it. So while the bones of the bill are probably going to end up looking the same when one gets, or when it's enacted legislation, at the moment what you're going to find is that things like the limitations that have been put into place might be challenged as being arbitrary. What the bill also does not do is it does not create a commercial industry. It doesn't create a cannabis industry, as it were. It only allows for the personal and private use, possession and cultivation of cannabis. So the bill doesn't deal with hemp. The bill does not deal with medicinal cannabis. That's the sphere of the Medicines and Related Substances Act. And it also, if I didn't mention this, it also doesn't deal with hemp, which is all of the commercial uses of the cannabis plant, of which there are tens of thousands, but specifically excluding the psychoactive uses of the plant.
All right, so just clarify for us then. I mean, when you walk through a mall, you see a pop-up store, you can buy little chewy teddy bears that contain CBD to help with your stress and anxiety. You can buy a lollipop. There are CBD stores where you can buy certain things. So where does all of that fit in when it comes to the law? And also products like, you could buy face creams that contain CBD oils and stuff like that. So where does it all fall?
Well, that's not addressed in the bill. There was actually an amendment to the Medicines and Related Substances Act, or the scheduling of that, which rendered certain preparations of cannabidiol, CBD, below certain thresholds. Those are Schedule 0 substances, which are termed complementary medicines. You still require a license from the Department of Health or the Director General in order to manufacture, distribute, etc. The end seller of those products is not required to possess a license. So the storefront isn't required to possess a license. But of course, the question is begged, where did they get that CBD or those CBD products, if not from somebody who was licensed? So this is a very gray area. There are people who are taking advantage of the gray area. And essentially, they are mavericks. And I take it that they are hoping that the law changes in their favor and that in the meantime, nobody comes down on them for doing what might be outside of the law. So
in the draft process now, Paul, what does it tell us? Let's just go back to the basics, I suppose. It's talking about growing and smoking it or making your brownies or whatever it is you do in the privacy of your own home. What's allowed, what isn't allowed? Well,
essentially, if I can just make one clarification, where it does allow for cannabis to be used as medicine is, of course, if you've decided to self-medicate with cannabis, if you want to grow your own cannabis plants because you've researched it and decided that it helps you with whatever ailment. But that's outside of the Medicines Act, because then you're doing this to yourself, essentially. You're not marketing it as a medicine. But what it says, essentially, is that there are certain amounts that you are allowed to grow in a private space. There's now a distinction between what is a dwelling and what is a private space, but of course a dwelling is a private space. What they say is that a private space is any space that the public doesn't have access to as a matter of right. And what that means is that you are not only allowed to use, possess and consume cannabis in your dwelling, there are private spaces outside of your dwelling which you may conceivably consume cannabis in. So If you allow your imagination to take over, you could look at a private members club where only cannabis using consenting adults are granted access to that private space. And what it says is that you are allowed to possess certain amounts of cannabis cultivation material. You're allowed to share that cannabis cultivation material, and using that cannabis cultivation material, you're allowed to grow a maximum number of cannabis plants, and you're allowed to essentially produce that into a maximum of 1 kilogram per person of dried product. And they also account for things like producing cannabis oil or cannabis waxes, etc. There are also amounts contained, or proposed amounts contained therein. If you go above those amounts, then you're going to be guilty, or you will be charged with a criminal offense. And you could go to jail for a lot longer than would be a rapist in this country. So we do have to ask the question as to whether this is truly giving effect to the intentions of the Constitutional Court, where possessing over the limited amount of cannabis could send you to jail for a very long time. It's still treated as though you are a reprehensible human being, one that needs to be taken out of society. And we do need to ask questions as to whether that's correct.
All right, just a couple more questions around what you've just told us, Paul. When you talk about the sharing of the materials, if I had to cook up an oil in my house, am I allowed to share it with a neighbor or a friend or a relative? And around the consuming of it, am I allowed to do it in my car outside of my house? Is that considered my private space, or is that still up for debate?
All right. Well, the first question, yes, you are allowed to share it as long as there's no exchange. So you can't. There mustn't be any quid pro quo. It must be a donation of that cannabis. If your neighbor is going through chemotherapy and you believe that they would benefit from some cannabis oil and they ask you for it, you would be allowed to help them out there, so long as you're not making medicinal claims. That would be the same as for all cannabis material. I mean, what they don't want is that when you pass your cannabis joint to your friend on your private stoop, that all of a sudden you're a drug dealer. So that is permissible. Whether your car outside of your driveway would be a private space, I would suggest that it would be. In terms of the Act, though, however, you would need to do it quite discreetly, because if anybody passing by your car were to smell the cannabis or were to see you consuming the cannabis, there is an offence created in terms of the bill for those things. So that would not be permissible in terms of the law. What it also says is that it's going to propose to change the Traffic Act, such as is the case with driving under the influence of alcohol. If you are found to have been driving under the influence of THC, which is the component that makes you high in cannabis, if you're found to be driving under the influence of that, you're guilty of an offense. Or for that matter, if you're even behind the wheel of a car that is turned off and you are found to be consuming cannabis, then that is an offense, because they're going to infer that your intention was then to turn the car on and drive away under the influence of cannabis.
Okay. And what about travel? If I were to be found, say, with my CBD oil, for whatever my reasons are that I'm taking them, or my face cream that's made is a cannabis cream, if I were to go through an airport, can they confiscate that from me?
They ought not to be able to confiscate that from you as long as you had it concealed. So your pockets, your personal backpack, those are considered private spaces. So you are essentially using a travel private space in order to transport your cannabis between private spaces. Obviously, what the bill does do is it talks about lesser amounts that you're able to travel with. So although you are allowed in your private space to possess, call it a kilogram of cannabis, you are not allowed to take that entire kilogram of cannabis with you between private spaces. I can't remember what the amount is, but it's a far lesser amount that you're allowed to travel with.
Okay, Paul Michael Keichel, thank you very much. That was extremely informative. I'm sure answered a lot of questions, although we are still waiting for a final word there. It's still a draft process, as he says.